where we give legal precedents or decisions made in court an academic angle. We exercise our academic freedom to learn more, to understand, to laugh, to criticize. And at the end of the day, we always leave this platform successfully educated. So today, our interest today is a very interesting case. But before I go to the case credentials and before I introduce what we're going to talk about today, I have to introduce the people who will make our day successful. Having Don Watson from JKUAT Karen, that's a journalist student. He finished his 4.2 from JKUAT Karen, a smart one. And I hope you guys learn from him tonight. We're also having Mokua Bichanga, who is also a finalist like Don, from JKUAT Karen. We are having Masila-JKUAT. Masila-JKUAT is a member of the Law Family Foundation, and she's a head of department in the Law Family Foundation. She forms the panel today critically to analyze the judgment we'll be talking about. We have Odilia Mayodi from Moi University, the resilient Odilia from last week's discussion. We don't know what she has in store for us this week, but we are hoping that it will be fun like last week. We have Miss Vanessa Mugo from Nazarene University, a smart mind that we met with in this legal journey, and we're going to learn from her tonight as well. The last one in that panel is a friend that I respect. We have gone through this journey together, met in few moods, and his resilience, the way he's been consistent, is outstanding. Martin Kioko, arguably the best moot in Africa, from Kenyatta University, is with us today. We also have members from the Law Family, Nazarene Kasura, Harrison Kuguru joining us from Mombasa, and a lot others from the Law Family in the house. Important to mention is that my mother in Moot is also in the house. The lady who taught me everything I know today, can say that way, in the field of Moot, judged me in my first Moot in campus when I was pathetic. And today is here to assess the growth of the son, Linus Maina. She's also mother of a lot of law students in YouTube and Instagram. She'll speak. I know she'll say a word. She'll greet us. She's in the house. From around 8:40 p.m., we are going to be joined by former MP in Diwa constituency, Honorable Augustinoh Netto Oyugi, who will also form part of our panel from 8:40 until 9:30. So with that, we get to the gist of today's discussion. So ladies and gentlemen, your moderator, the guy who will be making this fun or annoying at your own pace, will be Max Ogola. This annoying guy speaking here. So I'll start that today. Our interest is a case that is very funny, very fresh in the minds of young lawyers and in the minds of Kenyans at large. The case is a case that depicts the interest of 41 people, senior judges, who were recommended by JSC in 2019. And then the president submitted, and the Chief Justice submitted a list to the president, 41 people. This issue brought the Maraga Uhuru scenario that was in the country from 2019-2020 towards the end of the Maraga's tenure. And these 41 people were not nominated yet. And then what happened is that shortly after BBI fell, some people out of these 41 people were appointed to be judges of different courts in Kenya. Individuals who had their hopes high but did not make in that cut include Agri Muchelule, George Odunga, Weldon Korir, Professor Joel Ngugi, and the late Harrison Ogweno Okeche, who passed on last October. May his soul rest in peace. These individuals did not make it to the cut. And so an interesting question arose, that is it because Professor Joel Ngugi and George Odunga, because they took part actively in the BBI decision, could it be possible that it's for that reason, that's why they did not make it to the cut? I want to categorically state that our interest tonight is not politics or what was done or what ought not to be done. But the wording of Article 166.61b, that the president shall appoint. The wording of that particular article of the Constitution is shall. So is it discretionary? Can the president choose who to appoint and who not to appoint? How do we construe the meaning of that obligation of the government or of the president under Article 166.6b? That, among other questions, are going to form the basis of our discussion tonight. So with that, I open the introduction of the panelists. Let's start with Vanessa. Vanessa, are you in the house?
Very good evening, Max. Yes, I am. How are you?
I'm good. Your volume is way low.
Oh, I'm sorry. Can you get me correctly now?
No, you can adjust maybe way better.
Let's see. Okay, that's about the farthest I can go. I'm sorry.
Yeah, that's better. We can work with that one.
Okay.
So Vanessa, maybe because you're the first panelist in the house and we are picking this conversation right on. In your thoughts, can the president be sued on a personal capacity?
Well, Max, when you say suing the president in a personal capacity, I think what comes to most of our minds right now is presidential immunity. And from my understanding of the law and my, how I have dissected cases with regard to this, yes, indeed, I feel like the president can be sued personally as an individual. Yes.
Okay, so the president can be sued in personally. Hold that thought there. Let's see the other panelist who is in the house. Martin, hello.
Yes, sir. Good evening.
I'm trying to assess your pitch so that when your time comes to speak, at least you'd be audible.
Yeah. Can you hear me clearly?
Okay. I don't know whether it's my gadget or you are low.
Oh, really? Let me try working on it and hope it gets better with time.
Yeah, all right, bro. Odilia.
Hi, Ogola.
Hi, how are you, Mayodi?
I'm fine. I'm in the house. Glad to be here.
Yeah. Also trying to assess your connection and thank you for confirming in. Masila-JKUAT.
Yes, Ogola, I mean.
Okay, thank you. Donald Watson. Donald Watson. Maybe Don is not in yet. Mokua. Okay, thank you for that assessment. I had an apology from Don that he joined around 7:20. So Don and Mokua are not in yet, but we are starting our discussion now. So let's get back to Ms. Vanessa Mugo on the same topic, on suing the president on a personal capacity. The Constitution is clear under Article 143(2) that the president will not be sued in any civil or criminal suit under during his tenure. I'm not quoting it verbatim, but that's what they're saying, that the president should not be sued civilly or criminally during his tenure. And as I was reading the case, the reason why they were the legislative history of that particular article was to give confidence in the office of the president. That's what they were saying in the case. So that the president makes decisions when he's confident. He makes decisions without having to look behind his shoulders, literally, thinking that whatever decision he makes will be challenged in a court of law. So maybe your thought process on the same. Vanessa.
Yeah.
Yes. Max, can you hear me?
Yes.
Just a sec. Sorry, could you just come up again with that question? I was having a little internet problem.
It's okay. The question rather is this. You have said in the introductory statement that the president can be sued on a personal capacity, and we're just trying to learn here. So yeah. The Constitution inasema clearly under Article 143(2)b that time president atako in power, he should not be sued civilly or criminally. Now, okay, so the case that we're dealing with today, the appointment of judges case, which is Katiba Institute versus the President as the first respondent, the Chief Justice, and the Attorney General 2020. The President was sued on a personal capacity. So we are saying the President afai kusuiwa on a personal capacity to give him confidence in the office, so that when he makes certain decisions, he's so confident that no one is going to sue him for making those decisions. So tell us, maybe, why do you feel, or why are you of the idea that, or what are the scenarios when a president can be sued on a personal capacity?
Thank you, Max. First of all, let me just take you back to Article 143.2. And yes, I agree with you that a reading of Article 143.2 may lead one to a conclusion that, the president enjoys absolute immunity. However, the courts were, in fact, the most recent ruling I can bring you to. They've been. Let me dissect it this way. The very first time we had the president being sued, not even in his personal capacity. Let's focus on the cases of Republic versus the Chief Justice and 6 others. That is in 2010 with ex parte as Moijo Mataya. In this case, it was held that the president can be sued in his official capacity for constitutional and legal transgressions. But in the most recent case, the BBI case, the case of David Ndi and others versus the Attorney General and others, they actually brought to the attention of the court the fact that Article 143.2 actually, according to the Attorney General, was given that same reading that you're bringing out, that the president enjoys absolute immunity. However, the court agreed with the petitioner in this situation, where the petitioner was of the opinion that where the president acts in contravention of the constitution, he could be held personally responsible for any loss ensued. And the court agreed with the petitioner because it read Article 143.2 in tandem with Article 259 of the constitution that demands that a purposive approach to constitutional interpretation is brought out to give effect to the objects, purposes, and values of the constitution. So that is why, yes, I still hold that, especially when
Ms. Mugo.
Yes.
Can you hear me? Let me cut you short. Just a little reminder. Some of our audience are not law students, neither are they lawyers. And some of our audience have their parents or their siblings around them listening to us right now. So
Yes.
when we go the constitutional or the article way, they get scared. Yeah.
Max, I'll tell you what should scare them more. What should scare them more is having a situation where the president has absolute immunity. What this could mean then is that, and I like the way you have, the issue of presidential immunity goes back to feudal England, where, the position was that the king does no wrong. That is the best way I can put it to the layman, that king does no wrong. And even the United States Supreme Court seemed to hold this same averment in Nixon versus Fitzgerald, that the reasoning behind absolute immunity of a president is that it is necessary to prevent interference with how the president functions, such that it prevents distraction from his duties. But at the same time, you need to ask yourself why this same president we have had has been on the receiving end of such court proceedings. This is not the first
Privilege.
time we are yes. And of course this could be one could argue that it was rather audacious and unimaginable even in the Kenyatta and Moi regimes to bring such issues even before a court of law, let alone to mention them. But at the same time, you have to realize that the law progresses, and the spirit of the Constitution of Kenya at this point is to make sure that there is certain limits to every office created for the people. Yes.
Okay, thank you, Ms. Mugo. Just let's bring Ms. Odilia in the same question. Ms. Odilia Mayodi, what are your thoughts? Are you agreeing with Ms. Mugo that a president can be sued, so that tomorrow when we feel that Uhuru Kenyatta, for example, showed up on a gathering during the curfew times, past curfew, we can go sue him for breaking the law if curfew was allowed, for example, to stay?
Okay, I hold the same averment with my fellow panelists that indeed the president can be sued on a personal capacity because the office of the president has been initiated by the Constitution. That means that he is directed by the Constitution, and in the event that he violates any obligation set out in the Constitution, then he is answerable to the people. He is in that office to serve the people, and the sovereignty of the people will always stand no matter what. And we can see the function of the judiciary is to interpret the law. And as much as the Constitution,
Odilia, I think we're losing you. That was a nice line of thought, but we're losing your connection. Please check on your connection.
hi, Ogola.
My connections also had an issue because it's raining over here, but we heard what Odilia Mayodi said, that she agrees with Vanessa that president can be sued on a personal capacity. I'm trying to assess a panelist who sits on the same table tonight who feels otherwise.
Max, can you hear me now?
Good evening, Max. I feel otherwise.
Okay, let's have Mokua go first, then Martin will come in. Yes, Mokua.
Good evening. My name is Mokua Derek. I believe that the president may not be sued under certain circumstances, and this is my reason. First, he represents the total sovereignty of the people as he holds the highest office in Kenya. And not only that, he is also responsible for some key decisions concerning national security. Now, when you're talking about national security, you have to remember that there are some things that the public is not allowed to know, for the sake of the public. For that reason, there are certain decisions that the president may make that may seem to contradict the function of his office. And yes, the court may have a duty to declare that those actions are illegal insofar as they observe them to be illegal. But as it turns out, when even after this person leaves office, if there happens to be a suit put against him, there may be secret courts put up, and this matter will be investigated, and he still won't be found liable. So there are certain instances where the president may perform acts that may seem to contradict his function in office, yet he'll still not be held liable. Thank you.
So what is your position that there are instances, therefore, otherwise, when the president can be sued directly?
My position is that the president cannot be enjoined in a suit as a matter of procedure. However, this does not bar the court from making a declaration about what the president ought to do. Because we have to remember that whatever the court does has to be enforceable. And insofar as policing powers go, this cannot be done in practice. What the court can do is only make declarations, and if the president does not follow, after he leaves office, he may be prosecuted, and what the court declared before may be used as evidence against him. Thank you.
Thank you. Okay, so Mokua feels that the president should not be enjoined in a suit as a respondent, like it happened in this case that we are digesting tonight, the I case and so on. Whoever has that time, please mute your microphone. Allah. Anyway, so Mokua feels that there are instances that the president will make decisions that contradict what the public believes, and that a court can only make an order to compel a president on what to do, but president should not be sued as a respondent in a suit. Martin?
Yes, Max. I hope you can hear me now better.
Yes,
and
clearly.
that you can also see me.
We can also see you.
Yeah, thank you. First of all, thank you very much for this opportunity. I'm really happy to be part of this intellectual discourse. I'll say first that I think President Kenyatta has made most of us judicial activists by virtue of the fact that there has been a lot of violation of the constitution and disobedience of court orders and contempt of court during his tenure. So even those of us who believe in presidential immunity as a doctrine in law have had to grapple with sometimes not agreeing with it entirely. I will say this. I think in the 18th century, when the French social political philosopher Charles Louis Baron de Montesquieu coined separation of powers as a doctrine, he did not countenance a situation where any of the three arms of government, that is executive, judiciary, or legislature, would be at war with each other. He expected that there would be interdependence in the performance of their functions, and that there would be better government if the three arms of government are able to keep each other in check through checks and balances. And I think the possibility of having a president who can be sued, whether in his or her personal or official capacity, in itself seeks to portray the separation of powers. I believe in presidential immunity myself, because of course I agree with you to the extent that the performance of the roles of the president require peace and maybe a quiet tenure for one to perform best. However, I believe that the impregnable doctrine of absolute presidential immunity was retired with the former constitution or with the independence constitution. And that now the Constitution of Kenya 2010 provides citizens with an opportunity to see to it that the president is kept to account or is put to account in the case they do something wrong. And I would lastly refer just to the very recent, not very recent now, I think it's grown a bit old, the BBI judgment. And I'll go back to the High Court before we speak about the Court of Appeal. The High Court, I believe, pronounced itself rightly when it came to that question, because looking at Article 143, Sub-Article 3 of the Constitution of Kenya 2010, the president, or actually any person who holds public office, is protected indeed from illegal action. However, this protection is in respect of anything done or not done in the exercise of the powers that they have conferred under this constitution. The rationale for this basically is to give them nice or comfortable time in office. Most importantly, we need to also put in mind a scenario where we'll have a president or a state official who, during their service, embarks on a mission that clearly violates the constitution or is even destructive to the nation. At such a point, it will only be prudent that such a person be stopped in his or her tracks, rather than for us to wait for the end of their tenure for them to be brought to question. Because maybe by the time they leave office, the country could have plunged into chaos. So in conclusion, I think that in such circumstances, any person should be allowed to invoke the jurisdiction of the court and sue the president, actually, whether in his personal or even official capacity. I think in whichever capacity such a person is sued will depend on the nature of the violation or the threatened violation, and will certainly depend on the circumstances of the case. But while I am a lover of presidential immunity, I wouldn't take the doctrine to be in its absolute sense. I think that will be the beginning of a dictatorship, and it would be dangerous for any country. Thank you.
Well, I pick a few points from Martin that I agree with. the fact that there is going to be a set of tyranny, and tyranny is defined by Longful. If you read that case, actually, a state of exercise of power where the citizens have no rights. So there is a possibility of having that state of tyranny if we have absolute presidential immunity. However, it also brings in a certain aspect of a contradictory ideology when it says that a president cannot be sued civilly or criminally for acts done or not done while in office. The exact reading of Article 143(2). So it therefore means that maybe, for example, if a president commits a crime, like let's say for example, the president steals, so he decides to steal a watch of a cabinet minister. So that's an act that he has not done in office. Maybe they went to party with this cabinet minister in Sabina Joy and he decided to steal his watch. So there's a room where this president can actually be sued civilly. He's still a president. Do we mean that the veil of suing the president is just to the extent of his duties in office? Or is it a veil that cuts across, that once you're a president, you're not going to be sued until you are out? I think, Martin, you can come back for a minute to address that before Masila chips in.
Yeah, I can see my fellow panelist, Miss Vanessa Mugo, has her video on. It's always nice. I think I would also want to encourage colleagues here, if you can, it's good to have a video on so that we also get to see you. In response to that, the president is a symbol of national unity, and we all agree that the president stands at a point where they are very high up. Yeah, but I believe Avi Dicey, even in the conceptualization of the rule of law, to have a society that is equal, or at least believes in the perception of equality of the members of society, in a sense that it really matters not what your position is in society. If you are wrong, then you must still be treated like any other wrong member of the society. And the basis for this argument for me will be that we are not here to put a president, for example, at a pedestal simply because we want them to perform their duties. As I said, the purpose of the law sometimes is to look at the most difficult of circumstances, is to look at circumstances where we'll have a rogue president, someone who acts in sheer impunity, goes beyond violating the constitution, goes beyond disobeying court orders, and even goes to the extent of, perpetrating a genocide to his people or her people. In such a situation, we cannot rely on this doctrine of presidential immunity to say that this is a symbol of national unity. This is a person we expect to perform duties comfortably or quietly. I believe that even though we respect our presidents, we must stand for what is right, and they must always be brought to question as persons of high moral integrity in society. And they must always be questioned whenever they go wrong. Thank you.
Yeah, thank you for that clarification, bro. That was a sound one. Masila, and about the video thing, yeah, your point. I think this panelists should have their videos on. We have Masila on the same.
Hi everyone. Am I audible now?
Yeah.
Yes, am I?
Bar in your background.
Yeah, so I'm in Mombasa, so in the prayers, I don't know what you can do about that. Let me see what I can.
It's okay, bro. It's okay. We don't mind. Okay, Masila is gone for a minute. Don, do you think the president can be sued on a personal level? On a personal capacity? Let me make my video also on properly. Yeah. Yeah. Don. Don.
Yeah, Maxwell, I'm a bit indisposed at the moment. Can I get back to you in 10 minutes time?
Oh, it's okay.
Okay.
I think Masila should come back in now. Masila.
I hope this is better now.
Masila?
Am I audible?
Yeah.
Okay. So I concur with what Martin, Kioko, and Vanessa Mugo have brought forth. Indeed, the president should be sued in his personal capacity, and even the provisions that they have given. And the problem is when people talk about presidential immunity, there are two things that which Vanessa Mugo has brought forth. There's the issue, and that you've also said, there's the issue of that the president should be able to, perform his duties without having that lingering fear that he might be sued at any time. But then again, there's also the issue of, absolute immunity, and it may breed tyranny, or rather what you guys have brought forth. In a bid to balance that, my opinion, or rather what I opine, is that yes, indeed, the president should enjoy immunity, but not absolute immunity. It should be limited. In that, the immunity that the president should be sued on certain instances, for instance, matters concerning public interest, which the court actually held in Katiba Institute versus the Attorney General. Yeah, basically that's the opinion. Yeah, the president should enjoy immunity, yes, but it shouldn't be absolute.
Okay, thank you, Masila, for that. So that was an opening question, but it took so much of our time. Though I think you've heard what cuts across when we bring in the general audience contribution. We will still go over these questions. I just want us to first have a brief questions discussed by these panelists, and then we open our floor for free discussion. So the second question is from Article 166, 6B. The wording is, the president shall. But what happens we see is that the way I told you guys, Agre Muchelule, George Dunga, Weldon Korir, Professor Joel Ngugi, Harrison Obueno Okeche, these are individuals that were not appointed after the nomination list was submitted to the president. So the question that we rather want to pose to the panelists tonight is, the appointing duty of the president under Article 166, 6B discretional? Is it discretional? Is it just a ceremonial function? Mokua?
Thank you, Max. And yes, am I audible?
Yes, we are very audible. Did you get my question?
Am I audible?
Yes.
Oh,
Yes, I got the question.
Yeah, proceed, bro.
I got the question, and I don't say this, but one, the president represents he is the embodiment of the power of the people. For that reason, we cannot say that his role is merely ceremonial. As much as there's public participation at every point in the judicial appointment process, the president is the one giving it legitimacy, right? Yeah. So we have to look at this appointment process as a mechanism whereby there is the process that gives birth to something, is the one that performs this action. The fact that Article 166 says the president shall, it means that, sorry? Am I audible?
Yeah, very.
So the fact that Article 166 says the president shall, it means that the president is already bound. He has been bound, like he's part of a mechanism, and he has no option but to submit to the process that has come to him. You see, now that is the way, and we should interpret the Constitution according to its natural wording, and that is the proper way to look at this provision. Thank you. Perhaps I shall leave room for questions.
I don't know whether Max is able to hear us.
Yes, yes. Miss Mugo? Ms. Mugo on the same. I'm just saying, I was telling Mokua that there is no need for questions yet. These people are in here, they're listening, and these people are smart. Once you're done with the panel discussion, they're going to question each and every panelist. I know they're doing that. So I'm asking Ms. Mugo if she agrees with Mokua on the position that the function of the president and the wording shall does not mean a thing at all. It only means that the president is bounded by law, by the constitution, but then there's still room for discretion to decide who to appoint and who not to appoint under that wording. Ms. Mugo.
Okay, so my thinking of that is rather, just a second.
Kennedy Mwitosi, please cough when your microphone is off, kindly. Yes, Ms. Mugo, proceed.
Yes, I think I agree with him to a certain extent, especially because the Constitution does not per se allocate the president any power, specifically in any article to or the mandate to maybe comment or review a decision made by the Judicial Service Commission. So to this extent, I tend to lean on the fact that his role when it comes to appointment of judges is rather ceremonial. I tend to think that the wording shall is really binding on him. Chief Justice, the former Chief Justice Maraga, when he was asked about this situation when there was a stalemate, I think early last year, his position was that the Constitution does not pronounce or does not give him the mandate to even comment on what goes on after these names are submitted to him. His function is to organize for how these people are going to be, what do we call it, appointed. That is where he comes in. But at the same time, I'd like to critique that position. You see, the Attorney General in the case said that the president, as the head of state and the head of government, has exclusive authority, yes, to appoint judges in Kenya on behalf of the citizenry and in accordance with the Constitution. And in thus doing, and in thus saying, by failing to appoint these judges, he was not refusing to perform his duty as president to appoint them, but was merely taking steps to ensure he does so in accordance with the purposes and objects of the Constitution. So there's that balance that maybe he was doing it for the greater good. I mean, he's there for the citizenry. So maybe the names submitted, he needed to look at them. But even if this argument was going to hold, I think in this situation, we cannot see goodwill, allow me to say that, because the excuse, rather the reasons he gave for not appointing these judges were rather dubious. I don't know what anyone has to say about that, but I think it's really cut across. I am not fully settled on one side, but from the wording of the Constitution, I tend to think that his role here is basically ceremonial. You're given the names, appoint them, because the JSC has already done what it is mandated by the Constitution to do. And so long as they have followed the correct procedure, the interviews and the vetting were done transparently, they were done in accordance with, the spelled out procedure. Everything has been done, and it is the assumption that by the time we're bringing you these names, these are the best people. So it's not up to you to now go and do your own separate, investigation. But even if that could hold, I think in this situation, it really cannot.
Well, okay, before bring another panelist in, actually, let's just explore the same thought pattern, that there are three arms of government that coexist independently. So the judiciary decides under the body that is mandated under the judiciary, that's the judicial, under the Constitution, pardon me, that is the Judicial Service Commission. They approve, they recommend, then they forward this name to the president. Now, the president, being the executive arm of government, comes in and says, you know what, 6 of these people you have sent to me should not be judged. judges. Okay, is the president, as Mokua says, he holds the biggest aspirations of the people, but shouldn't there be a separation of power? Like, is the executive, access to justice is for the people of Kenya against another person of Kenya, including even the president. So if the president has a say on who sits as a judge, then tomorrow I feel as a Kituo cha Sheria or as a Katiba Institute that there are rights of the people that have been infringed. So you have taken a public interest litigation against the government before the Supreme Court. Shouldn't it, doesn't it look clearly that definitely the president's judges that he appointed outside the others that he didn't appoint will definitely make a judgment in favor of the president? Martin, what do you have to say on a president having a say on who becomes the judge?
Okay, yeah, thank you. I agree with you to a certain extent that the president should have a say on who becomes a judge. And I say this not because I do not understand the independence of the judiciary, but because of what I had mentioned before. Yeah, the principle of separation of powers calls for checks and balances on one hand, as well as interdependence between the different institutions of government. However, well, I agree with you to the extent that the president should have a say. I direct you to the provision. I'm sorry, I forget it. I'm trying to find it on my constitution. On the composition of the Judicial Service Commission. And I think this is one of the arguments that was made, that the president is represented in the Judicial Service Commission by, is it 2 or 4 persons who are actually presidential appointees to represent the public service as well as
we're kind of losing you.
That is the youth. Sorry? Oh, yeah. So my point in this case is that the president is indirectly represented in the decision-making organ of the judiciary, which is the Judicial Service Commission. And therefore, in the process of vetting the judges before approval of their names, the president has a hand. In the case that there is difficulty in agreeing to the appointment of one of the persons who are before the Judicial Service Commission, then the president at that point in time can put up a challenge or ask questions about the integrity of these people. You see, the problem with the move that we have currently is that the president appears to have made this decision as an afterthought. And many people believe that it comes out of the BBI judgment and some of the decisions that have been rendered by these 6 judges that were never appointed. So while the president is rightly invoking his prerogative as the head of the executive arm of government in trying to check the judiciary, he does so first in a way that is not permitted, and therefore he invokes malice in his decision. And if it is something that he actually believed in, that these people were not competent, then the right time, in my opinion, would have been during the vetting process before these people are approved to him. Otherwise, I take the role of the president, just like Vanessa, to be one that is ceremonial. Just like when we have a bill presented to the president for assent, if the president doesn't take it back to parliament and it passes a certain number of days, then it becomes a bill. And I think it's the same logic that we should apply here. Thank you very much.
Thank you. Maybe Miss Odilia?
Okay, Max, I will invite everyone to note that the wording in the Constitution is the president shall and not must. So as much as I agree with my fellow panelists that indeed it is ceremonial and everything, but I believe that him being the emblem of the sovereignty of the people, excuse me, has the role to question, as Martin Kioko said, has the role to take back the process to the Judicial Service Commission to vet and to investigate the integrity of the other members who are supposed to be appointed in the bench. So yes, the president's role is not ceremonial at all, alone, entirely, but he has a role, and it is not for procedure alone, but he is the executive, he is the head of executive, and he has to exercise his power with, he does not do that alone, but we should also recognize that he has legal advisors, and that is not a decision that he arrived with his thought entirely, but invited other quarters that thought for the good and for the best interest of the people of Kenya.
Okay, thank you. So we have two factions. We have Vanessa and Martin, strongly believing, and I think they make a good point from their view, that there are representatives of the executive already in JSC. So that if the president has an issue with any of the judges recommended by JSC, that issue needs to be resorted in-house before it comes to the appointing. So that on the appointing, it becomes a ceremony. On the other side, Mayodi and Mokua also are making a very strong point on their view that the president represents more than just a signature. And that as a head of the executive, and as Mokua said earlier on, there are certain decisions that have to be made that we don't have to know. That's a discussion that the audience will jump on later on, I know. So the president is not a mere signature. The president is a lot more than that. And so when it comes to the appointing of judges, the president must have a say. Let's hear what Muthina thinks. I wish we could have heard what Donald Watson thinks, but he's still on.
Okay. I'm here now.
Donald, go for it.
Yeah.
Yes.
Okay. Good evening to you all.
Good evening.
I think I will take divergent views on this matter. I'm actually split between the two factions because of different aspects. First, on the language used in the Constitution, and I would like to borrow a speech by, I think it was Lenaola, Justice of the Supreme Court, once he was actually talking about the position of advisory opinions, whether advisory opinions are binding or not. And he said, how can an opinion or a recommendation be binding upon a person? It's just an opinion, and that is in as far as it goes. So a reading of this Article 166.1, it says the president shall appoint the Chief Justice and whatever with the recommendation of the JSC. So my first view would be, how then would a recommendation to the president be binding to him? Yeah, the wording used is shall, but it still remains a recommendation. The second view I take is, yeah, the position is the appointing power is ceremonial, for reasons I think Mr. Kioko has alluded to, because I think it was in the case of Wasame and Wasame versus the G, where they had refused to. Am I audible? Max, am I audible? Max, I cannot quite get you.
What?
Max. Max, am I audible?
So, well,
I think Max, you are the one with the issue. I thought I'm not audible enough. I think one person from the audience has told me I'm audible enough. Okay, then I will proceed, and I said I want to agree with Mr. Kioko. He said I think he actually alluded to a judge to a segment of the judgment in which they said the president's representatives in the JSC are the two persons representing public service, and I think the vetting process is quite a rigorous process carried out by the JSC. So by the time these names reach the president, I think it's a final list. So there is no point in wavering the list or trying to cherry pick from the list or whatever. And my final point would be, and it's something that the court made mention of. They said the president did not appoint the six persons left out from the list of appointed judges. the president cited the issue of integrity and all that, but the court noted that no evidence was adduced to that effect. So I think it was actually an afterthought from the president, and I do agree with Mr. Kioko on that point. I think that is all I have to say for now.
Thank you, Don. I don't know whether you can hear me. Yeah, thank you, Don. Thank you. That was a brief, good one. So I'm not going to bring Masila on this one because I'm starting the next question with Masila. Our audience are very ready. I'm seeing Kevin Bet from the Kenya School of Law. Very, very ready. Yes, guys, you're going to come in, but let's get done with the panelists first. And then we have an open window discussion. The third question was rather, what is the format or the procedure of appointing judges? What is the format of appointing judges so that the public can understand from what point does the president come in? Miss Mayodi.
Mr. Ogola, just 1 second, if I may.
Yeah.
I really apologize for hijacking your discussion, and I apologize again to the other panelist who is just about to start speaking.
Yes.
My name is Grace Maina. I am very happy to be here, but unfortunately, I have to log off from the call, and I thought if you could just indulge me for 1 minute, then I can let you proceed. Is that in order?
Yes, Mama, you are so allowed. You are so allowed, Mama.
Thank
Proceed.
you. Thank you so much. Again, I apologize to all the panelists for hijacking the discussion, but I'd first want to say thank you so much, Mr. Ogola, for having me. I'm very proud to see that all the young minds that I worked so hard to mentor while at JKUAT are doing such an amazing job at this. And I have followed the discussion for the past hour, and I have to say I am quite impressed to see, the level of understanding and comprehension of the law. And even as I log off, I just want to throw a spanner in the works and raise some of the issues that I think from the first two questions, maybe as you continue, even as the audience will be coming in, can be addressed. And particularly, I was happy with the first question on the question of presidential immunity, since that was actually what I did for my dissertation. And a lot of you seem to lean onto the side of a president should not have immunity. But as I would tell you in a moot court session, I would ask you then, why is it absolute immunity? What was the purpose? What was the intention of the Constitution in saying that there should actually be absolute immunity? And some of you have attempted to make the argument that, when the president is doing his work, then he shouldn't, have something hanging over him as a court case. But again, he should not be allowed to have presidential immunity. And just to broaden the scope of the case that you are reading, I'd also want you to think about it. If you do say that a president should not have absolute immunity, then what happens in the context? Would you then be okay with the ICC coming and trying your president for various crimes, or would you not? Because when it comes to the questions of immunity, you cannot fail to look at it also from the perspective of sovereignty. And the sovereignty of a nation sits with the president in this country. So what then was the Constitution trying to remedy? What was the issue trying to fix? And as the judiciary was making that decision, and they did say that the president can be sued in their personal capacity with regards to issues on violation of the Constitution, what reasons did the court give? Did they just say that he has violated the Constitution and that you should sue him? Did they give a system? And I remember one of the panelists quoted Montesquieu and saying that the concept of separation of powers may not have foreseen the whole issue of the conflict in the three arms of government. But actually, a reading of that jurisprudence will tell you that that is exactly why there is a separation of powers, to make sure that there is independence of the three arms of government to make that decision. And from that independence, you can then proceed to have a system of checks and balances to make sure everyone is in line. So that's my thoughts on the first question. And I really encourage all of you to be bold. And as you make your discussions, really don't be afraid of stepping on any toes. This is one of those platforms where you're allowed to be as radical as possible and to share your thoughts on any of these issues. So I hope even as the audience is listening to this, that as you continue, you'll raise it. Very quickly on the second issue, I'm happy how you have sort of covered this because there's a division on the panel. You're not all just leaning to one side. And that's that's what a good debate looks like. But look at the Constitution and look at what courts have said with the wording of the Constitution, and it says shall. It is not, as some of you have said, it is merely ceremonial, but you also have to look at the conflict of laws. When you have the Constitution, it is said to be the supreme law of the land. But you have to also remember the Constitution is just a skeleton. The meat of what feeds the law, the meat of what enforces the Constitution is a statute passed by Parliament. So you cannot have this discussion without looking at what the Judicial Service Commission Act says and what it talks about with regard to the appointment of the judges. Again, I know you're also avoiding a political discussion, but in this country, you cannot really remove yourself from that. You also have to think, what is the political climate? By the time they say that there's issues of integrity, you have to go back and ask yourself, when people say the judiciary is corrupt, is that a well-founded claim? Is it a claim that is merely perceived bias of the judiciary? So I encourage all of you, even as you discuss this, remember the Constitution is one source of law in this country. Judicial president is another source of law. I encourage you to read widely, to read broadly, to be broad in how you debate some of these issues. And with that, I really want to thank you for the time that you've given me to speak, Mr. Ogola. Thank you for having me. I will be fully on next week. I know that I'll be part of the discussion next week, and I'm very much excited that I got to experience just a little bit before next week. And I hope you have questions. Again, thank you so much. I wish all of you a very blessed night. Keep reading the law, keep being the very best versions of yourself, and I'm very proud of all of you. I hope you're all blessed. Have a good night.
Thank you so much, Grace. Thank you for that, the insight, the explanation, and all that. And we are waiting to have you next week so that we can have a fruitful, expansive discussion. Maybe just before you leave, Nazarene Kasura is one lady in the law family that looks up to you so much. So maybe a hello from you to Nazarene would mean a lot tonight.
Oh, yes, I know Nazarene. I've met her online. Just on that note, thank you so much for all the people who watch my channel on YouTube and for all of you who actually reach out and talk to me. Thank you, Naseda. Actually, I've seen your message. Yeah, so please keep doing your very best. If you want to reach out to me, please get in touch with Mr. Ogola. I'll give you my number. I think I'm very available. Ogola, am I available? When I'm not busy, I do try and get back to everyone. So yes.
Okay, thank you, Grace. We'll be holding Grace Maina here next week. She'll be a panelist for our Huduma number case, alongside Quinta Chieng from Kenyatta University and the controversial Kiiru Mburu. We'll also have a guest advocate, the director of Kituo cha Sheria, Dr. Annette, will be in that panel. It will be a fire ladies panel. And we thank you so much, Grace, for showing up tonight. As we proceed with this discussion, let's pick a few things that Mama has told us. That it's a free platform to talk about how you feel, and that we need to examine everything we say along the wording of the Constitution so that we understand it deeply. Thank you for that. So we were proceeding with the panel questions. There are only two more to go so that we open this discussion to the public. And the second one was, because we are talking about appointment of 41 judges case, could maybe one panelist take this honor to tell the public how judges are appointed, the bodies that are responsible for appointing judges, the procedure until the time, not for appointing, pardon me, the bodies that are responsible for that nomination, verification, and all that of judges until the appointment is done by the president. Ms. Mayodi, Odindo Yoga, please mute your microphone. Odindo Yoga, Allah. Mayodi. Mayodi. Well, it seems like Miss Mayodi is not in. I don't know whether it's reconnected or something. Don. Watson. For a moment, I questioned whether I'm the one audible. All right. Don Watson and Miss Mayodi are not in. Martin? These panelists are clever. They're shying away from the question of the procedure of how judges are appointed. Maybe let's use this to break ice a little. I'm having a lot of text messages directly and even in this platform from people who want to speak. So let's start with Kevin Kibet. Kevin Kibet is joining us from the Kenya School of Law. Yes, bro. Kibet.
Yes, Council, yes. What was the question?
There was no question. You wanted to speak, you raised your hand, we're giving you a platform, bro.
Oh, I thought, oh, okay, for the appointment of judges, I will comment. But now I wanted to comment about the three things that you've already discussed.
Yeah.
First was presidential immunity, and then the second one is for Article 166, and then that one for the procedure of appointment of judges. Now, for the first one, whether the president enjoys absolute immunity. Well, according to the Constitution, when you read that is Article 143 of the Constitution, there are two things. There's the criminal and the civil. Now, the question is, for the criminal, I think it is clear that the president is protected from any criminal suit. But now for the civil, that's where there is a debate for the civil, whereby the issue of the personal capacity and the official capacity of the president. Now, when you read that specific article, as the people have discussed, it says that some of them have said that the president has absolute immunity. But now there is an important thing that we need to consider in that specific article. That is powers that he has been conferred under this constitution. Now the question is whether any violation of the constitution is, now the question is whether a violation of the constitution can you sue the president? Now, because the president took an oath to protect the constitution, and yes, it was in relation to the constitution. Now the question is whether there is absolute immunity, because a violation of the constitution, it means that the president is not adhering to the specific law that he swore to protect. But now, in relation to this specific case, this one for the constitution, this one for the Katiba Institute, now the case, the issue before the court was about the appointment of judges. Now, when you read that, now the question is whether the president has the role of the appointment of the judges, and that is in Article 166. 166, which says that the president shall appoint judges. Now, when the president violates that specific article, can you sue the president? Can you sue? Now that is the question. When the president has violated that Article 166, that one for the appointment, is it something outside his role in the Constitution? That is the only. Is it something outside the Constitution, and also is it something that you can sue the president? You see that now that because when now because now in that
let me cut you short because you're coming back, and also in the interest of time, I'm seeing Alvin Kubas who has raised his hand. So as the panelist prep over that question, your analysis of whether the particular determination of whether president can be sued on a personal capacity is subject to the case in hand. Lakini for our academic freedom, or for our academic exercise, we are trying to analyze kama president, the immunity, should it be sound like venye kwa constitution that the president is immune, or should there be limits? So I'm liking the points you are raising, but hold the thought there for a while. I'm bringing you in. Alvin Kubasu.
Thank you. Can you kindly confirm that you can hear me?
Yes, and your hand is raised. Thank you. We can hear you.
Thank you. So I wanted to weigh in on that issue of the appointment of judges. And so,
Okay.
and I like the level of arguments that you are raising in, but here I am thinking from a point of, first of all, this is we are having, it's like a sibling rivalry. So among us three, that is the three arms of the government, the constitution does not say who is the eldest, who is the youngest. So we have to fight for our space, in quotes. And then here we have a place where we are trying to say how the judiciary has interpreted to say that the word shall, what it means, and the position of appointment of the judges. But I'd just like us to take a step back and understand something, which I like the fact that Martin alluded to it, the fact of the separation of powers. So if we are to agree with that point of, actually, once the JSC has nominated, the president is only supposed to come and say, thank you for doing a good job. There you have your judges, and it's barely it. Then where is that separation of powers coming in? Because the judiciary has that point of saying, we want to vet our persons who become judges, and we will nominate them, and you will only accept them. So where is separation of power coming in? Because unlike a bill where you can actually, the judiciary can declare to be unconstitutional, what happens if these persons that have been nominated by the JSC, they are not fit to hold office? Ideally, there's no other place because the parliament cannot debate them. But then also, something else to take note of is when we say that the president actually has representative in the JSC, you know, the president cited, I mean, I agree that there must be, maybe it's an afterthought, but then when he says that he has some integrity issues, these persons who represent the president in the JSC, are they privy to the information that the president gets from the NIS, for example, the National Intelligence, whatever, something? Are they privy to that information? Then it begs a lot of questions, because he might have representatives, but then they are not receiving the information that he is receiving, which maybe is supposed to be tabled to his desk only. So when all is said and done, I think it's also something that not to look at it from the point of the judiciary being a victim also, but then also from the point of each one of them is fighting for the space, and therefore each one of them ought to be given that subjective and objective outlook as far as this issue is concerned. Thank you.
Thank you for that. And maybe just to bring in the last audience before we bring our panelists back, Kirumburu talked about something in checks and balances in the chat. So Kirumburu, after listening to people have these different ideas on the same, and being the fact that you are forming panel next week, I'm delighted to bring you in. What was your issue on checks and balances on the same, Kiru? Kiru. Kirumburu. So maybe Ruben is not close to his gadget, but when he does, we'd like to hear what he had to say on the checks and balances issue. Because I think Alvin Kubasu has drawn the line that in case, or even though there's the checks and balances between arms of government, the president sits at a seat that is more privileged with information. And maybe we need to look beyond just the judiciary being a victim and analyze certain aspects of management of government that include, privy information that reaches the president even before it reaches his representatives in the JSC. Well, with that, we are bringing our panelists back to the discussion, and we will bring the audience in back at large. That was just an icebreaker. The third question I asked was an outline on how the judges are being the procedure of nominating, verifying, and appointing the judges. But I'll keep that question for later. So we have this question that what is the extent of the supervisory function of the High Court in relation to equal jurisdiction courts? This was a question I wanted to grapple with these panelists, because as you read the case, the Katiba Institute versus President Chief Justice in AG 2020, a certain aspect of the Adrian Kamoto case comes in a lot. That is for the people who read the case. And one thing was that the decision in the Adrian Kamoto case was also a decision of another High Court. So the supervisory function comes in as a contention. So this is actually a point of study. that yes, the High Court is in a place of privilege as well to supervise decisions of lower courts, all lower courts. But the High Court, according to the rule of stare decisis, cannot supervise the Court of Appeal and the Supreme Court. So back to the panelists, what are your thoughts? Are there instances when the High Court can supervise decisions of another High Court, or decisions of the labor law courts, or the decision of the environmental court? Or does the supervisory function of the High Court only vertical, and there is not even one instance when it can be applied vertically? Watson. Donald Watson.
Yeah, Max.
Yeah.
Okay, I think when you asked the former question, I was having trouble with my internet.
It's okay, bro.
I apologize. Yeah. So, okay. I think the question is the extent of the supervisory function of the High Court in relation to equal jurisdiction courts.
Yeah.
My opinion on this is quite simple. I think a reading of which article is this? The system of the courts.
165.
That is 162. 162. I want to read 162 as read together with 165, because you've made mention of both the Environment and Land Court and the Labor Relations Court. Yeah. If I got you clear, Max.
Yes.
Yeah. So my point is, yeah. So my point is really quite simple. Yeah, it's quite simple here. These are courts of similar stature. They have the same status as that of the High Court. So I don't see how the High Court can now start supervising or exercising the supervisory jurisdiction over courts of similar stature. And so I think these mandate or these jurisdiction and contemplated under Article 165. 165. It will be 165. I think it only applies to subordinate courts. I think that is my position.
There was a concern that the people were trying to enforce the decisions that were made in the. Let me get that clearly. But before I shoot that specific question back to you, let's hear what the other panelists have to say on the same. I'm bringing in Ms. Masila.
Masila? Yes, I'm saying.
Yeah.
May I respond to the question that was raised first before I proceed to the other limb of the argument?
Sure.
Yes, so someone has raised about separation of power, and I think when we're having this discussion, on appointments, recommendations, and all those words that will be thrown around, it is important for us to differentiate between the judiciary and the Judicial Service Commission. The recommendation is done by the Judicial Service Commission and not the judiciary. And if you appreciate the composition of the the Judicial Service Commission, you'll understand that the two are very different and are established by different provisions of the Constitution. Now, using that context, it is important to know that separation of power is only limited to arms of government. And therefore, we cannot not separation of power, I'm saying checks and balances. Sorry, checks and balances is a principle that's only limited to arms of government, and Judicial Service Commission is not an arm of government. Yes. And you asked about the format of appointing, or rather the procedure of appointing judges. I mean, a proper reading of Article 166(1), it gives 1A and then 1B. The first limb is about the CJ, the Chief Justice, and then the Deputy. Now they're recommended by the Judicial Service Commission, approved by the National Assembly, and then appointed by the president, and which I still opine that he or she plays a very ceremonial function. Yes. And then now the second limb of all other judges shall be recommended by the Judicial Service Commission and then now duly appointed by the president. Then the last limb is what is the extent of the supervisory function of the High Court in relation to equal jurisdiction of the court. And it is my opinion that the article, or rather the Article 165, sub-article 6 and 7 of the Constitution is very clear that the supervisory jurisdiction only extends to subordinate courts. So it cannot exercise, the High Court cannot exercise its supervisory jurisdiction upon another court of equal jurisdiction. Yes, thank you.
Okay, sound on from Masila, the breakdown of the 3 points. I'm having a message chat from John Muasa. Was the High Court sitting in a supervisory court on an enforcement court? Or an enforcement? John Muasa, can you just come clearly to ask the panelists this one? Because I saw your message on the chat. Any minutes from now, ladies and gentlemen, will be receiving Honorable Augustinoh Netto Oyugi. We'll be capturing these very topics we are capturing, but on a senior position as an advocate and as a member of parliament. So before then, even before we delve in as audiences, I'm trying to rush so that we get all these issues that we wanted today fully addressed, and we also chip in your ideas so that we learn from you guys. So Mr. Muasa. Hello, John Muasa.
Hello, John Muasa. Yes, can you hear me?
Where are you joining us from?
Hello.
Where are you joining us from?
Oh, I'm joining you from Machakos, exactly, to be precise. And so my question was
okay, proceed.
Yes.
Proceed.
Okay. So it was necessitated by the question you asked on whether the High Court can sit as a supervisory court on the decisions of another High Court somewhere. So my question was, in the case that we are discussing, was the court sitting as a supervisory court or an enforcement court? Was it sitting to enforce the orders that had been given in Adrian Kamoto? So that was my question. I hope it's clear now.
Kioko. I'm trying to get Kioko the same, but Mokua Bichanga is in the house. Mokua, Adrian has a question. In the decision that we are dealing with, was the High Court sitting in as an enforcement court or as a supervisory court in relation to that Adrian Kamoto case? The Adrian Kamoto case was the first case that raised the issue of appointing judges, appointment judges case. Are you in?
Yes, I'm very in, Max Ogola. Now I'm going to be trying to be short. So number one, to answer the first question, I'll start with a story. Once upon a time, Jesus was asked by Pharisees, there's this lady we found committing adultery. What should we do? Now, in that story, if Jesus would have said, stone the lady according to Moses' law, Jesus would have been found guilty of sanctioning murder contrary to Roman law. If Jesus was to say, do not stone that lady, he would have been found guilty of violating Moses' law. Now, this is the same situation this is the same thing that was presented. If the court decided to find that the president acted in violation of the Constitution, he would have enforced the judgment of the previous case. But if the court would have found that the president would have found the decision to the contrary, it would have meant that the High Court was supervising, like revising the decision made by the other court. So it was sitting as both, basically. Secondly, there was an issue raised by Grace concerning the absolute immunity of the president, especially in relation to ICC prosecuting the president. Now, the president receives his power from the national constitution, yes? The national constitution is powered by the sovereignty of the people. The ICC receives its power from international covenant. Now, the question we should be asking ourselves is, which of these two powers stands above the other? Obviously, it is the spirit of the national constitution. Therefore, it is principle, it is a matter of constitutional principle that courts are the ones that interpret the law insofar as the president's actions are concerned. And where the courts lack the strength of interpreting this law in the public interest, the public interest is not barred by municipal law alone. It can now appeal to international law, whereby now the ICC may come in. And it is this is a very important point to note, because if a national court is competent to try matters of within its own national jurisdiction, the international court's decisions are of no importance to the nation. But if the judicial structures are so compromised that they cannot cater for the public interest, which is actually the notion of republicanism, right? Then the international court can have a duty, which is also reflected by the United Nations Declaration about Human Rights, to interfere and make proper decisions. Number 3 is concerning the supervisory role of a high court. Now, we're talking about horizontal and vertical jurisdiction. Talking about vertical jurisdiction is about the stare decisis rule, whereby the constitution gives a hierarchy of courts from the magistrates' courts to the Supreme Court. Now, this hierarchy of courts is meant to cater for appeals that are of similar matter regarding similar parties. And now we have to look at the issues that come before the court. Issues that come before the court are of either criminal or civil matter. Criminal matters are specific and designed in the they are posited in the criminal code. But civil matters are dynamic, and they are to be decided upon individual merits and circumstances. Now, a constitutional petition is unique in that it is a rigid set of positives that affect the greater public. You see, for that reason, a constitutional petition of the same matter may be litigated by 2 different parties. In this case, it was argued that as much as this matter was similar, the matter was not res judicata because the qualifications for res judicata were not met. And insofar as my judgment is concerned, I see that too. So we are not saying that the High Court is supervising the decision of another court. Merely, we are saying that the High Court is litigating on a matter that is similar yet affecting different parties. And at the same time, we have to balance the finality principle and the justice principle. What do we mean by this? That it is public policy for matters to be finalized, right? But at the same time, justice, equity may not suffer without a remedy. So insofar as a high court litigates on matters that are similar to another court, to a court of similar competency, the matter has to be of such weight that the public interest in it outweighs the finality principle. The decision that must have been reached in the previous court must have been so absurd, such that if this court were not to admit this suit, then it would amount to a blatant violation of justice and principles of humanitarianism. Thank you.
Well, that was Professor Mokua Bichanga for you on Hermanus Philippus Stein, grounds for public interest litigation, well analyzed on the concepts of jurisdiction and supervisory duties of the High Court. I think he has touched on it. We are leaving this platform before our guest comes in for the audience. Whoever has something to chip in, either on the supervisory jurisdiction of the High Court, either on the format or outline of verification, nomination, appointment of judges, either on the discretionary or otherwise function of the appointing of judges of the president, or whether or not the president can be sued on a personal capacity. The floor is yours. Let's learn from you two. So I'll start with Santos Michel. Santos Michel is joining us from Moi University before dawn. Santos.
Thank you very much, Max. I hope I am very audible.
You are very audible.
Thank you. So I will touch on the issue of the duty of the president in appointing the judges. Is it discretional or ceremonial? Well, this is enshrined in Article 166(1)(b), as we are all very aware. But I would like to invite you to Article 132(1)(f), which says that the president shall appoint or dismiss state officers to his own discretion as long as it is constitutional. For those who say that the power of the president to appoint is ceremonial, please let us put side to that article, because it gives the power to the president to either appoint or dismiss. So in dismissal, we mean that he dismissed the recommendations of the Judicial Service Commission in appointment of the judges. I would also like to quote what one panelist said. I think it was Mokua, when he said that we should look at the natural wording of Article 166. The natural wording is that the president shall appoint. English, shall is an obligation. Appoint is to give a job, to name to a certain position. His job is to give a certain position, recommendations that the Judicial Service Commission have given to him, and not to give his own feelings. Yes, let me see, sorry?
Yeah, it's still your time. I'm still listening to you.
Oh, thank you. And then, sorry, one sec. I think my gadget is misbehaving over here. No, I think I'm done.
As your gadget recovers, I think that was a good one. I saw Oduor Otieno raise his hand, and then for the yes, Oduor Otieno. You're still in the house and your hand was raised. Go before dawn comes back. Oduor Otieno E. Well, okay, the gentleman probably changed his mind. Donald cannot hear me. Oduor Otieno is not responding.
No,
yes,
no,
Jessica?
I can hear you. Actually, you are the one who was having issues again. Can you hear me now?
There was a gentleman I was calling, Oduor Otieno. He raised his hand. I'd prefer he goes before you come in.
Oh, okay.
Because I'm also trying. Oduor Otieno. Well, you can proceed, bro.
Okay, can I proceed?
Yes, bro. Yes, you can proceed. Sure.
Okay. The issue actually I have with this judgment and its final orders is the extent of enforceability of the same. Why do I say so? The High Court does not really tell us what should. Okay, let this be my starting point. I think Grace was quite clear when she said we cannot quite dissect this judgment from its political nature. And I think it was the LSK president, Nelson Harvey, mentioned quite something about the judgment. And he said the judgment on the appointment of the 6 judges is not a further indictment on the president. He feels like it's the biggest test on the Chief Justice, whether she's executive aligned or independent. She can only pass it by swearing in the 6 judges on 5th of November 2021. So as a follow-up to what Nelson Harvey said, I think the question with the enforcement capability of this judgment is, the High Court does not really tell us what should happen next when the CJ does not make arrangements to swear in into office the 6 judges. It is so my issue then is, will the CJ be cited for contempt and punished when there is non-compliance with the orders therein, or and I think someone has their mic on.
Kindly mute.
Okay.
Yes,
so my
proceed,
issue is, my issue is, and I think I will pose this question to my fellow panelists and to members of the in this forum. So what happens then when the CJ does not make arrangements to swear in the 6 judges? Will she be cited for contempt or for non-compliance with the said orders? Or even if so, which High Court will then try to cite the CJ and maybe the JSC for contempt? I think, is it really possible then? Because we all know the implications that maybe the CJ can simply make a phone call and that judge be transferred to Moyale or wherever. So then my question is, my question then stems out from the 2 issues, which I would like probably anyone to answer or to respond to the same.
Okay, before we bring your panelists, I think the disruption we just had was our guest trying to come in, and I'm really waiting for him so that we slot time in between our discussions so that he spends his time before we finish. But I know that when he joins us, I will know, he'll inform me. Oh, he's in. So in the house with us is the Honorable former member of Parliament in your constituency, Honorable Augustinoh Netto Oyugi, who is our guest tonight. It's a honorable day for me, and I think for Martin, because Honorable Augustinoh Netto Oyugi was the 4th best oralist in 2004 in a moot that around 3 or 4 weeks ago, Martin Kioko won. And today they are sitting in the same panel and we're having a discussion with them. I think it's a historic moment for Martin. He's a former member of parliament from Ndiwa, the way I said, and we hope then he becomes a member of parliament again in 2022 in the same constituency. He was the vice chair for Bunge Sports Club and he served in JLAC while he was in parliament. So because we are law students, the first questions we always ask is, when a member of MP was in parliament, what act did he push or what was his bill? As I was doing a little digging to him, found that he pushed for the Health Records and Information Managers Act. It's in history that he did that. He championed the refugee bill, the reparations bill, and the employment skills and development bill. Currently, Augustinoh Netto Oyugi is the co-director or co-party leader for the United Green Movement. I met this gentleman, I learned from him, and today I'm delighted that we are spreading his wisdom or his knowledge to all of us. So with that brief introduction, let me welcome the Honorable to just say hello and address us on his points. I know he's sound on the points that he wants to address. Bwana Mheshimiwa.
And human rights law, or law in
Thank you very much. I'm just trying to actually get off another setting altogether. My apologies that I'm joining late, and I know I have less than 10 minutes because you're supposed to finish at 9 o'clock. So yes, Martin is well known to me. Martin, how are you? Good evening, big man. Is Martin on the panel or is left?
was just in here right now. If it's not his connection, then I don't know what it is, but I'll get him back right away.
Not a problem. No, I mean, I had a chance to meet Martin slightly before he left for his mood in South Africa. That was it. And Martin and I are from the same alma mater. So he's a young man that I've met before, and I think I'm super proud that you people are doing a very good job. My apologies, I'm joining in late. I've just walked out of a class. Actually, it's not even finished. So I hung up because I promised to be on the call at 8:30. 8:40 or thereabouts. I know it's 10 minutes late, and I know I don't want to keep you waiting. So one, it's a pleasure that people are doing this kind of work in the middle of the night. It is the best we want to do for country. Always ensure that one of the lessons I learned from my father, which I will properly write at some point. I was told that he who hopes to reach the height should not sleep at night. Does not mean you become a night runner of Ndiwa, but just that you burn the midnight oil. You burn the midnight oil in terms of how you work and do your things. So I'm really happy and delighted that you're doing this. Two things I'd like to say, which is what I want to talk to, because I have to be in traffic shortly. I wanted to speak to the question as to whether the presidential appointments are ceremonial issues. And to that question, I want to say yes and no. There are moments, for example, when the presidential appointment, I want to do the two questions that I saw on the panel thing. There are moments when the presidential appointment is ceremonial. You know, Kenya, being Commonwealth, inherited the sort of constitutional democracy where the president is both head of state and
I think we kind of lost him, but he'll bounce back. So don't ask a question before we, oh, he's here. So we kind of lost you. Your connection has a problem. Yes, so can we have Jessica Dama? I've seen you from the chat box that you just logged out. You raised your hand, so maybe you could have your issue before the Mheshimiwa rectifies his connection.
Okay, I don't know if you can hear me.
Yeah, we can.
Okay, thank you. I'm Jessica Damar from Moi Law School. And I would like to respond to the question to do with the concept of checks and balances. I'm of the view that it is applicable in this case. And first of all, I'm of the converse opinion with the position in the David Ndii case, which proves to hold that the state should be accountable for his actions directly, thereby limiting their freedom to make certain decisions where they deem fit. According to me, the concept of checks and balances, which I believe is applicable in this case, is of importance since it warrants a derogation from the faithful execution of a particular law. And in this case, the president should have been allowed to derogate from appointing the judges if there was reason to believe that these judges did not have the integrity that it deserved to get into those particular positions. And yeah, that would be my opinion. Yeah.
Okay, thank you. Martin, Netto was looking for you. Kioko. Kioko. Am I audible enough, or am I the one these people are not getting?
We can hear you, Max.
can hear me. So it's Martin's connection that is not clear. Thank you. Well, before Martin bounces back, before Honorable Netto Oyugi bounces back, that's why this online stuff gets tricky sometimes. Let's open this discussion for the general audience. We know that you're students of law from various institutions, and it's not in my position to call you out to speak. If there is a topic that we were discussing today, Oduor Otieno, then go first, bro.
Thank you. Thank you very much, Max. Good evening to everybody who is joining in, the panelists as well. I think I'd like to touch on two particular issues. Number one, checks and balances, obviously, because it seems to be a very big issue of contention. And particularly what I opine is that there is a two-part obligation here. The Constitution, in my opinion, has already dispensed of its obligation very diligently. It has already provided ways in which powers can be separated from the executive, the judiciary, and the legislature. The Constitution has already done that part. The other obligation now lies upon the people who are sitting in this position of powers, particularly the president, the CJ, the members of parliament. So what the president is doing here, he is abjectly just trying to derogate from the principle that has clearly set out in the Constitution, because the president does not have any mandate. There is somebody in the discussion who clearly said that the role of the president simply ends when he has been told to appoint. He has no mandate of trying to decide whether these people that he's going to appoint, because we have the JSC who are supposed to do their work, and they have done their work up to the point when they have submitted those names to the president, and all he is simply supposed to do is just appoint. It is simply a ceremonial role. What the president is doing, and even the Constitution has clearly set out that the judiciary is an independent body. The president should not have any say at all. He is simply just trampling upon the Constitution. It's a clear injustice. The Constitution has already done its obligation. So what the remaining part, the remaining obligation that rests on the people who are sitting in this position of powers, they are simply the people who are just doing injustice. We are in a democracy, in a dictatorship. And then in as far as supervisory jurisdiction, particularly for,
yes,
particularly for the High Court,
listening.
I am sure that we are privy to the fact that there is horizontal precedence, particularly that a High Court can overrule its own decision at a later time. But also, I think it is important for us to know the fact that the Constitution has clearly stated that the High Court does not have supervisory jurisdiction over superior courts. And the Constitution has also stated what these superior courts are, being the Supreme Court, the Court of Appeal, the Court of Equal Statuses, etc. But I think even when it is trying to apply any doctrine of horizontal precedence, it's supposed to do it at a very light note, not at a very heavy note, such that, and the law, by the way, the law has stood the test of time, such that any petitioner who has ever tried to lodge a claim before the court, trying to say that the High Court has supervisory jurisdiction over any superior court, has always been rebuffed by the court. So just showing us that the law has stood the test of time, and we cannot go back to any position of saying that the court has supervisory jurisdiction over any superior court. So I think it is important that we shy away from that interpretation. So yeah.
Thank you, Duor. I think you've raised two issues that Mheshimiwa was talking about in this back. So let's get his view on the two issues that he wanted to handle, and then we will proceed with the open forum discussion. Yes, Mheshimiwa, if you're back in the house, it's your time.
Yeah, thank you very much. I'm sorry, but now I'm in traffic and I might not have my video on because I'm actually in darkness, so you won't even see me. You'll only see my teeth.
No pressure.
Even have my video on? So yes, I was saying that with regard to the executive power to appoint, if it's ceremonial, I said on the one hand it's a yes, and the other hand it's a no. And I was saying that depends on what particular appointments.
but I saw there were specific questions with regard to the Judicial Service Commission appointments, with regard to judge appointments. To that extent, I think the presidential appointments are ceremonial, and the president has no discretion whatsoever to choose which of the judges he wants to appoint or not. I mean, like happened in the case of Odunga and my very good friend and former alma mater, Professor Ngugi. You know, the construct of the constitution is such that you have a check and a balance system with regard to the three arms of government. And the way that the president checks the judiciary is not in the manner of refusing to appoint the judges that have been recommended by the JSC, you know, because the JSC then has legitimacy. You know, there's a process from which the judge appointments are done. You know, anyone who has, and you saw this during the appointment of the Chief Justice, where the Honorable Martha Koome was successful, that anyone who has an issue, for example, against a judge, if it's a criminal issue, if it's a case that he or she did not do properly, you can raise those issues at the preliminary stages before the JSC recommends the judge for appointment. So to the extent that, for example, the JSC has allowed or forwarded, recommended a judge for appointment, the president's role then becomes a ceremonial function. And ordinarily, like I said, our construct, the Commonwealth construct, was like, you know, like in the UK, where the Queen, who is head of state, would then have a chance to meet with the judges, or it is that sort of ceremony. It is more of who are, you know, they might not have a chance to meet in the day-to-day running of the affairs of the state. So the ceremony of the appointment, you know, it would be an occasion, for example, of the Chief Justice, the other judges then to meet with the executive, you know, in a less adversarial manner. So that is actually the role that the president then has with regard to the appointment. It's more of, you know, getting to meet. It's a meet and greet affair, as opposed to a legal or a constitutional imperative that the president then thinks there's discretion. The second thing that I wanted to speak to was with regard to the yes, when the presidency has a role, and the role then is, you know, when it becomes issues of, for example, the independent commissions, or issues with regard to the cabinet secretaries or things like that. The president then has a chance, for example, to remember, even when the president has then discretion to say or recommend, if it's, for example, a commissioner of an independent commission, the presidency, if at all they have issues, would then refer those fellows, for example, to further list of people to be made available to him, as opposed to. So whereas, for example, it's in the independent arm, like the judiciary, the president's role then is ceremonial. But when it is with regard to the executive or other independent commissions, the president then has an executive role that then is mandated to execute. That's the first thing I wanted to say. The second thing, of course, the question that you asked is, what's the procedure? You know, the procedure, of course, of appointing judges, like you've seen, is the application process. The qualifications are in the constitutions enshrined. So if at all you, for example, qualify 15 years of legal experience and stuff like that, then you're subject to the JSC, and upon the JSC giving you a recommendation, then you ought and they have a chance to be appointed, to be made judge and stuff like that. And no one else has a discretion to refuse to appoint you. If should you, for example, be appointed on day one and someone has issues with you, or issues that were not then properly ventilated before you became judge, then the procedure of doing a petition for the removal of a judge then is still available, so that the check and the balance system that the executive has, or the discretion that the executive has nothing to do with the executive using his whim to refuse of his own motion to say, I'm not appointing you because I was told by DCI that you have a case. That procedure then of removal of a judge then takes effect upon the recommendation of the JSC with regard to the appointment of a judge, so that whoever then wants to remove a judge then follows the procedure of the removal of a judge, which then is, do a petition. The president then appoints a tribunal. The tribunal subjects the judge to a session, and then, of course, if they're found culpable, then they're removed from the role. So that is what I wanted to say. I wanted to be very brief because it's been a long day, and I'm happy to engage in a variety of issues. Thank you very much.
Thank you very much, Mheshimiwa, for making time and deliberating on those issues. Maybe just on one issue before we let you go. What are your thoughts about suing the president on a personal capacity? Like, yes, there is the creation of the law under Article 143(2)(b) that he should not be liable on civil and criminal suits. There's the creation under Article 156 that gives mandate to the represent the government, the president inclusive. But what are your thoughts when a president now comes into power and grossly, let's say for example, like the case we're dealing with in here, a president that perpetrates something like a genocide. So what are your thoughts? Are there leeways on when a president can be sued, or is it complete immunity in the court?
You know, you ask for two different things. When you talk about the crime of genocide, the crimes against humanity, then, you know, those are then peremptory norms of international law, principle of use cogens, principles that therefore you cannot derogate from. So when you're dealing with non-derogable rights, then it is not possible to, for example, say someone has immunity. Yeah. So, for example, the reason why the President Kenyatta or William Ruto, for example, should they be found culpable of having committed crimes against humanity, the crime of genocide, then there is no immunity that you can then you can then not rely on the presidential immunity at that particular level, and you see. In fact, the question that you asked me now makes me speak to something else. You know, there was an attempt at the time that President Uhuru Kenyatta and William Ruto, Deputy William Ruto, were at the Hague. You remember there was an attempt by some ill-schooled members of parliament to, for example, remove Kenya from the Rome Statute. You know, they said that they would do, for example, have Kenya withdraw from the Rome Statute in a manner that would, in their view, would have been giving immunity to the President Uhuru Kenyatta and President William Ruto from non-prosecution. Now, you must remember that that when it comes to crimes or international human rights obligations that have attained the principle of use cogens, then you cannot derogate. You can then not say that if you go out of the Rome Statute, for example, a president stops being culpable, and the same cannot be used against him. I mean, you could just suppose that with the case of the United States and with regard to the crimes that the US citizens committed in Iraq, for example. They're just being disobedient. They're just being unruly as a US and not having their citizens subjected to the International Criminal Court. But there's no principle in international law that stops them from being subject to the International Criminal Court. So it does not matter that you're not even a member of the Rome Statute or that you're not even a signatory to a state, to a convention or treaty that has attained the international principle of use cogens. So I will leave that at that particular point. Now I'll go back to your issue. The president can be sued for criminal acts, but not when he is in office. So, for example, if we think the President Uhuru Kenyatta has committed some criminal things, when he gets out of office in September next year, those charges can be brought against him. So to the extent that he's still in office, we cannot then use our municipal courts for those of you understand. We cannot use our domestic courts to try a president for purposes of criminal acts committed while he's in office. But however, when you know that crimes do not die, so that 20 years down the line, if, for example, your young generation thinks that the President Uhuru Kenyatta made certain things or did certain things that in our view were criminal, we can still then use or bring those things against them and charge them in a court of law, but not when it's existing or existing substantively as the head of state.
Thank you, Mheshimiwa. Yeah, a lot for the enlightenment on the preemptory norms of this cogens. That was a smart one. Thank you so much for making time for us tonight and for that engagement. We're 8 minutes past time waiting for you, but it was a long wait. We appreciate so much your time tonight.
My apologies, I should have come in earlier, but I had another class, so I'm sorry, that's the reason I came in late. Thank you so much for inviting me. I look forward to future engagements, and God bless you and all the best with your work.
Thank you so much. Wonderful. We'll talk further. Let's close this discussion. Samuel, please. Yeah, so we are 9 minutes past time, and I projected that we finish latest around 9:15. So at this moment, I'm going to bring back my panelists who are still in the house, maybe one last parting shot, and then we will close with the case that we'll be doing next week. So let me start with Mayodi Odilia. Are you still in the house?
Yeah, I'm in the house.
Yes.
And
just one last close, because you sat on the panel today.
What I would say is, I am also following closely, looking at the news, the national television, and this is a bold movement that you see that the court held the president liable, interpreted the constitution liable on a personal level, looking at the Bindi case, looking at this case, and looking at the Adrian Kamoto case. This is, it really shows that the judiciary is bold, and the independence of the judiciary should be protected at all costs for the right to justice of the citizens of Kenya to be realized fully. Yes, thank you.
Okay, Ms. Vanessa Mugo, are you back?
Yes,
Ms.
Ogola, I'm back. Allow me to just say that I think what should be the greatest takeout the audience and even us as panelists and everyone who's taken part in this conversation should be, the biggest takeout should be how we should first of all thank this constitution. I think we should first of all appreciate where we have come from as a country. The fact that we are even able to have a conversation like this and ask whether the president can be sued is already a great step. So that and many other takeouts, but I'm very happy I was here. Sadly, though, I was supposed to join another meeting at 9, so I'm not sure I'll be able to catch the conversation on the next meeting, but I'm sure you're going to prep me for that. So yes, that's all.
Okay, thank you. Donald Watson.
Yeah, my parting shot would be perhaps to say that we are indeed in interesting times, as we have seen from the case. The case has brought with it new ideas, new issues of concern, and indeed we are in uncharted jurisprudential waters. And what remains to be seen is actually happenings in the next 7 days or so with regards to this case. So yeah, I think it's an interesting case that we need to follow up on, and yeah, I'm really happy to be here. It's my first time to be a panelist, and we hope. Max?
Yeah, thank you, Don. I was listening to you, though we kind of lost you towards the end, but I heard you. Thank you. Masila Faith. Faith, are you still in? Okay, Mokua Bichanga.
Yes, thank you. I would, contrary to the sentiments of most of us today, mine is a song of lamentation. We have talked of the way the boldness of the judiciary and the visible presence of the rule of law. But on my end, I'm seeing something of dissonance at a fundamental level, a disagreement on matters that we don't expect there to be disagreement on. And for me, I'm worried because if we don't appoint judges who are going to decide these cases, I mean, do we not want a country that is under the rule of law? And I'm just wondering, just like as Don said, we're living in interesting times, and I'd very much like to witness what will happen after this tenure. Thank you.
Thank you, bro. Martin Kioko.
Yeah, thank you for the opportunity again. Sorry, I lost my connection at some point, but my last comment will be, first of all, I'm happy with this discussion. I think as young people, we have an obligation and a big role to play in governance and in assessing some of the jurisprudence and other things that are going around the country. I will just comment briefly on judicial activism, because I've said, I think one of my beginning statements was that President Kenyatta's tenure has made some of us very activist. And I will say this, yeah, much as I am someone who supports the rule of law and a judiciary that is strong, I'm quite concerned about this activism, because the counter-majoritarian argument usually is that, you know, judges are not elected. Sometimes, and many times, you'll find that they rule against the majority, or in a manner that is really not in the best interest of running the state. So my last point there will be that, much as it's something that we celebrate now, that we agree with the decision by the judiciary, it's something that must concern us going forward. Should we get to a point where the judiciary now overrules the public in a manner that is not agreeable to most of us? And I would ask that we just think about that as we live. Thank you very much.
Thank you, Martin. And so, because two hands are raised and Max Ryan has not spoken, I'll just give him this platform so that he says what he wanted to say before we close our discussion, and then I'll end in a minute. Max, I see your hand raised, bro. Max Ryan. Well, thank you, ladies and gentlemen. Okay. Yes, you can say whatever it is, bro, then close. Time is yours.
No, thank you for organizing such a forum. It's eye-opening to many. At least we get to discuss issues of national importance before we get to that level. Thank you for also bringing in the Mheshimiwa. Good work to the panelists. Good work to the moderator. You've done a good job, sir. Cheers. Hope to see you again in the next discussion. It was my first time, though. I enjoyed it. It was interesting.
Thank you so much, Max. Actually, you've given the vote of confidence that Max over here wanted to give. So, vote of thanks. Yeah, vote of thanks. Thank you, Max. Anyway, it's been a long day for most of us. It's been a long day for the panelists. Some of you, some of us, we spent the whole day doing other things. And then when you make time between 7 p.m. to 9 p.m. to come here and learn, to engage, to talk, it's of value to you guys and to us a lot. So I appreciate tonight. Normally when we discuss these political conversations, this one that touches on the government, we have a very low turnout. But there's been consistency in the turnout. So when we discuss these other social cases like the GBV ones, you guys are in masses. But it's good to make time to learn from both sides. You learn the political aspects of life, the social economic aspects of life, and the decisions they are in around you. So tonight it's just a big thank you to all of you. And the panelists by name, that is Bichanga, Mokua, Mayodi, Odilia, Martin Kioko, Faith Muthina, Masila, Donald Watson, Vanessa, Mugo. You guys did, Mokua Bichanga, yeah, once again, you guys did a commendable job. You had a very long, boring case to digest, and you made it interesting in the digestion. So thank you. I thank you all who are members of the public, and I'd like to have you guys in the panel as well, who took time to come and learn. Now, maybe you've learned something, and maybe next week, if you want to be in the panel, you can hit me up. As we work along the members of the Law family, we can get you a slot. Next week, our guests will be Grace Maina, who was just in. We will also have Quinta Chieng from Centum, also a graduate from Kenyatta University. We will have the director, the national director of Kituo cha Sheria, Dr. Annette, coming in, and a few team from Kituo cha Sheria. We will share with you the case in time, and we hope to see you again in numbers with your friends. Tonight has been a success because of you. Thank you so much, and have a good night. See you next week. To the members of the Law family, you can stay behind after people check so that we say 1, 2. Thank you, Ted. You can finish the recording so that we can speak freely.